So this is interesting. I just come across this as well. So this is just part of some other records. It's one of the entries into it. This is 1712. It's saying from 1700. That's when they did the Act of Settlement. 1700, by the way. It's not long after 1688. From 1700 to 1712, right? Jurats were elected justices of the peace for the coming year. But in 1712, this practice was discontinued on the note that according to the charter of James I, all jurats were automatically justices. So according to the charter of James I, right? Oh, right. So that's James's. James was before William, before the Bill of Rights. James is apparently one that William Penn got on friendly with and released a lot of people, although the accounts that I read made him out to be a villain, but it seems quite the opposite. It seems like James released a lot of people and then got on with William Penn, affected the Bill of Rights, but then he stepped down from being king. William came in and then it didn't go too good. But it was all a trade-off for more authority of Parliament and the people. But I don't think that William Penn was that happy with it, to be honest, by the sounds of it, with Anne and then George. But it says that the Charter of James I... But anyway, hold on a minute. So here, I've just got this jurat. So it says that a jurat is, historically, a person who has taken an oath or who performs a duty on oath. Example, a juror. Right? 2, a statement on an affidavit of when, where, and before who it was sworn. Well, that's what I said. I said that when you draft and write a petition and it is presented as the truth with your evidence, as this is like, you're supposed to have a statement of truth on everything, that, this is the truth. But they don't do this on Parliament petition website because they're... because it's like play school, basically. What else can I say? The Petitions Committee in Parliament, we're treated like play school because they don't take it seriously. So they don't have a statement of truth on there. Although when you click that, I think you might tick a box, when you fill your name in and your postcode, and I think you might tick a box and confirm it. Maybe that's like, maybe like, these are my details, so therefore my statement also must be true. The thing with the petitions on the HM Petitions website currently at the moment, in the present day, is that you submit your petition with 20 signatures and then you want it published so you can collect more on it. But they say like, oh, you can't have that link on it, or this is defamatory, or this is wrong, or it leads to false information. But how do they know it's false? They haven't got the time to research it all anyway, unless it's definitely going to be debated, all those petitions. If you put a statement of truth on there and you say this is the truth to my best of my knowledge, and you're trying the information in front of a jury, in front of the people, right? I mean, look at Hansard. Hansard, I found the other day, has got like lies in it. There is no such, there's no current rights for public meetings. Lie. There was a Public Meeting Act 1908. The Petitions Committee at the moment is so play school that Cat Smith, it really would. I mean, sometimes you see, these MPs turning up at schools, doing a bit of PR, turning up at schools doing finger painting. Jeremy Corbyn does, you know, I'm not knocking him for it, but that's the level that it's at. But that's not a joke. It's not comedy. It's not meant to be funny. It's actually serious. This is like, you know, Dr. Tess Lowry getting 116,000 signatures to protect the rights of the entire nation from the World Health Organization. And Mark Franchise going, you know, well, can they take the rights, yes or no? And I don't even know what committee's dealing with it, right? Yet, when Dr. Tess Lowry submits this petition, it's limited to, like, you know, 500 characters or whatever, and, you know, she could put links on there and information. They call her in to get evidence. They call her in, oh, come in, Tess, you know, give some evidence, let's have a meeting with you, and then pop up next to Mark, you know, and you can watch the debate, you know. But what about the evidence that the people want to see, whether or not they think they should sign the petition or not? They want to read the details, you know, where's that link? And Tess Lowry believes that is the truth to the best of her knowledge, and then we'll read it, and then we'll decide what we think, although we can completely disregard the law if we want anyway, you know. Where's all this? Statements of truth, fact, it's legal proceedings of the highest calibre on Parliament, but yet it's play school form, you know, and they still don't take it seriously. The seriousness of it could not be, you know, Rishi Sunak, when he goes into a meeting and smiles and then shakes the hand of his colleague and says, yes, I could do that deal for $5 billion. It's fine, Mark Zuckerberg. Yes, $5 billion it is. Can you get some of your minions to make some more widgets for us in the Oompa Loompa factory? You know, but that's not a joke. You know, that's a film. It was published and released on television, you know. It's, you know, it's, there's a lot of money in that. When they get the policy out for that deal and the contract, I don't think Rishi Sunak, likes to get play school forms out when he's doing $5 million deals with, you know, Professor X or, you know, whatever it is, Moderna or whatever. But when the entire rights of the entire nation are under threat, we get the play school form, you know. But all this is serious business, you know. The statement on an affidavit, or when and before whom it is sworn. Well, you can have a civil. It doesn't have to be. An affidavit is a criminal charge. You can have a civil claim with people sworn in on it to the writ. So, you know, really, I think the jurats are also the people who you get to sign the petition to, you know, the witnesses as well. Because your witnesses are sworn in at court as well. Well, they get sworn in when they actually have to go up and give evidence. They're sworn in. From 1700 to 1712, certain jurats were elected justices, right? Or some of them. So some of the jurors, if you're a jurat, you have been sworn in and you have taken the oath. Some of them are elected justices. I don't know whether that's like who's going to be the foreman, you know, like, because I think in that William Penn case at the Old Bailey, and I only read it the other day, who's going to speak for you, or our foreman. So they elected a foreman, didn't they? It was just as a piece for the coming year, but in 1712, this practice was discontinued on the note that, according to the Charter of James I, all the jurats were automatically justices. Hold on a second, then. Right, yeah. So James I was 1500. So it's referring to an earlier charter. So this is not James II. I was thinking of James II then, which is, you know, he was friends with William Penn and got a lot of people released. In fact, I think James and William Penn are probably accounted for the Bill of Rights, and then, you know, the deal with William Orange. But so actually, from 1700 to 1712, certain jurats were elected justices of the peace, for the coming year. But in 1712, this practice was discontinued on the note that according to the Charter of James I, so that's well earlier, that's like going back then to 15. So they've made a decision that prior charter legislation, that really, this is what I said. I said that all jurors really are a justice of the peace, at least for that when they're sworn in for that session. So they are justices, but they take an oath. The thing with the actual petition itself, this is only according to Google, by the way, but it's the Google's saying that a statement at the foot of an affidavit naming the parties, stating when, where, and before whom it was sworn, etc. Well, if you're petitioning the king, you are using the king's procedures and rules, and you are confirming that what you are claiming is that you're swearing that it's the truth, and you are, consenting to. You're going by the official procedures and process. It's a due process of law. That's the whole thing. That's why you've got to go to a court in the first place and have a fair trial, because it's a fair process of law. Otherwise, it's just a lynching mob, right? But when you're saying, right, we'll use the king's process, the king's rules, we'll use the law, we'll make it legal to effect and sign and swear in and submit our evidence and state our case, and everyone signs it, and then this is what we're officially doing. And then when you're going about doing that, that's what you're pursuing, then, you're sworn into the document. That's why I always have said that, the right to petition is because of the lawful due process, This confirms that all jurats are automatically justices, or at least for the matter of concern of which they're sworn in for. This is actually after. This is very, very. This is probably this bit of writing that I've just found here in National Archives. Right. This actually. This is probably more important than the Tumultuous Petitioning Act for indemnity. I think this is more. This bit here. This is actually more valuable for proving the 1688 Bill of Rights, right to petition. This is probably more important to find than I've discovered the claim of right. And probably the petition of right as well, because I think that this confirms the basis for the 1688 bill. The only thing with the 1661 Tumultuous Act is that the thing is you're allowed a jury. If you allow 20 people to sign. You get 20 people. That it's done. You're all sworn in, and you're on. And you are in hot pursuit. So, but getting large numbers of people, evidence of wider support, and potentially, remonstrations had to be given consent by some more people, like a larger grand jury. It's almost like going for a Big Mac, isn't it? From getting a Big Mac or having a quarter pounder. But I don't really want to use burgers as an example. It's not a very good example. It's kind of like I'll go large. You got to get permission. If you didn't get permission, that was an offence. But the irony in the William Mead case at the Old Bailey is that case is such a conundrum. If that really happened, and that was the actual guy that ended up, forming the colonies and then ended up befriending, James and so forth, so in 1670, he's in the Old Bailey and he's speaking to people in public and getting large crowds, and he gets accused of getting a large number of people behind a political cause or consenting to it without consent. He gets in the court. The jury say that he wasn't doing that. He wasn't getting the consent of people to a political cause at all. He was just speaking in the street. So he wasn't even. They're saying that he wasn't even doing what he was. He wasn't doing anything literally except speaking. The irony is that if he did get people to consent to a political cause, and he has got protection, but he didn't have the consent to get more than 20 people. You have got protection and immunity when you're doing it, ironically, but you have to get consent to expand the case, you know? And also to hand it into the king to submit it, present it. Although you can present it, I think you can present it by yourself over 10 people. Oh no, you can't present it with over 10 people anyway. But so I think the current government believe that because of that 1661 Act was enacted, that it can put certain restrictions and curbs on activities. But the thing is, after 1688, how could the 1661 Act even be possible after 1688? Why would you even want more than 20 people on anyway? Parliament seemed to be ridiculously... Why did Parliament demand 10,000 or 100,000 signatures? Before they made the online and the internet business, all you had to do was really submit a very strong, compelling case, You only really need witnesses if you don't have any other evidence. But if it's a big matter that the whole country's got to go behind, then I suppose you've got to show that people are behind it, like changing the law on something. But other types of cases, like to show corrupt and, like to prove corrupt and legal practices, for corrupt and legal practices prevention, doesn't really matter how many people sign it if you've got evidence of a corrupt and legal practice to prove it, This is like on the Inquiries Act, Part 1, A and B, it's it can be judged on the evidence or evidence of public concern, that's like the jury, that's like Magna Carta, that's like, it can be judged on point of law or the opinion of the people, like, we want an inquiry into, fairy liquid, causing rashes. Well, it doesn't cause rashes, well, we still want an inquiry into it, because we can have one, if the people want one, if 3 million people tell Rishi Sunak that they want a public inquiry into fairy liquid causing rashes, then, 3 million people, Sunak should really have an inquiry or have a referendum on it if 3 million people sign it for sure, regardless of whether there is evidence for rashes or not, on the basis that people want an investigation into fairy liquid causing rashes. This is it. But this is that is exactly, I said that. I've been saying this for the last month or two in videos. That there, just written there, look at that. I said that. I've been saying that. I've been saying that for the last few months. This is what I said. It's just like working it out. I had an intuition about it. It's just logic. And there it is right there. So, I'm going to take myself a nice little screenshot of that and put it up with the Jurat shenanigans. This is on National Archives. I don't think the police chief's going to like that. I've just found an amazing petition about highways and roads. And I think I'm going to send it to police chief. Look at all these. There's all this to read through. So, where's that bit from? This is from the minute books. So the minute books are the records from the Assizes. Minute books, the minute books. So they're only meant to be a brief recording. They're only meant to be like a brief record, the minute books. So what's this one from? This is at Kent. This record is held by Kent History and Library Centre. It's TES23 in the minute books. These minute books contain all the official business transacted by Tenterden Corporation and its various courts and meetings. Don't know what's going on with this corporation though. These were closely allied as they consisted mainly of the same people meeting in different capacities, and similar orders and appointments might be made in any of them according to convenience from 1662 to 1730. That's quite a long time. Although that's well within the... This is going on while William Penn is alive, by the way, in the colonising America. The Assembly, or Common Hall, appears to be the dominating body in the mid-18th century, and the records of all courts were badly kept and almost non-existent. After 1752, the Court of Quarter Sessions appears to assume more importance, and largely because it had acquired responsibility for finance, and almost all orders for the collection of spending of money were now made in quarter sessions and not the assembly of the Common Hall. So that on here, this is when they actually it actually tells you that a lot of the criminal cases were taken on by the quarter sessions and the assizes from the hundreds, but you see those quarter sessions and assizes were only coming around once or twice a year, and four times a year and twice a year. And they were the judges from London who were going around doing the circuits as well. So these hundreds, these are people who are sworn in as justices. Interesting that they call it corporation, but I guess they can get sworn in. Unfortunately, this is what's happening nowadays. A lot of mayors and councillors. I found out now, just on that Cultist Council Watch, it turns out that a lot of these councillors have got involvements with companies and business interests, when people who are commissioning and voting on actions in council aren't supposed to be allowed to have business interests and their own personal benefit or profit out of it, particularly if you're a commissioner, like the Police and Crime Commissioner, or commissioning highways and so forth. But you can only commission highways and so forth if people have voted on it in the chamber, you know. I suppose the public, you know, if the public, you could be on a jury and have an interest, but then you're just part of a jury, aren't you, you know? Then I guess there's always one person in the jury who can agree or disagree with something. But then again, usually it's the person who objects to it on the jury, isn't it, rather than those who are in favour. You could get people in a corporation. If they're wanting to get something passed and the jury are biased, then they're not going to have one person who's going to want all of the jury to not be opposed to it. So maybe it would work out all right that way. Non-payment of the Justices of the Peace gave more power over the levying of rates by various 18th century Acts of Parliament, so that the election of money for the upkeep of essential services was now in the main authorised by quarter sessions. Seems like the powers went up from the courts up high, from the local courts up higher. Then is that what it's saying? And then when you remove the jury, then you don't really have the local area people or the grand jury making decisions. It's all justice, isn't it? Election of mayor in these minute books is shown as in taking place annually on the 29th of August, irrespective of the day of the week on which the date fell, with the exception of 1658, when in accordance with an Act of Parliament made in 1654, the ceremony book, with the exception of 1688, when the same change occurred, vacancies among the body of jurats were filled at this ceremony. Through the number of jurats was often allowed to fall very low because new ones were elected. Vacancies among the body of jurats were filled at this ceremony. though the number of jurats was often allowed to fall very low before new ones were elected. Officers chosen included the common clerk of the town clerk, he was called, the chamberlain, the first sergeant of the mace, the second sergeant of the mace, the councillor or town assistant, lawyer, from 1658 to the governor of the workhouse. So the first and second sergeant was appointed clerk of the market. So it says that these aldermen and the mayor and the justices were usually people of local. I think you're getting like this is sort of a little bit like, you know, when in that William Penn and William Meek case, you've got like the recorder. The recorder seems to be pretty much controlling proceedings, and the mayor doesn't really say much, and the alderman. The recorder's kind of acting almost like a legal advisor, but they've got a clerk as well who's separate. According to this, surely you can't have the clerk's the clerk, isn't he? The clerk or the town clerk. The common clerk or the town clerk. Chamberlain, first sergeant of the. They've got a couple of. I think they've got constables present, haven't they? It seems like, you know, it seems like the police, shall we call them, when they're apprehending and getting criminals, they can also sit with the court, you know, or possibly even on the court. It's also like when you get Peter Fahey lookalike popping up at Salford Magistrates Court for a joke, but it's not funny. It's like intimidation. The keeper of the Gaol and House of Correction. And also from 1774, keeper of the Gaol and House of Correction. So for the keeper of the £100 as a deputy mayor was appointed. Appointments of attorneys to the court record were made. What's the House of Correction? Don't know. Look it up. Certain jurats were elected justices. This is what I've read. I've already read that bit. Apart from that's priceless. Apart from the years, it is always stated the charters, seals, office, and mace. Officers who took charge of the seals and maces are specifically stated. After 1754, the maces were the custody of the sergeant. You gotta be joking me. From 1641 to 1660, the charters are given as those of Henry and Elizabeth, the copies of the charters of James I and James I comes between the destruction of the county hall in 1661. That's when they made the tumultuous act. Only Charles I's charter and the composition are mentioned. And after 1685, only the composition. From 1691, no charters were handed over till in 1700. Exemplification of Elizabeth's charter is mentioned. Why don't they mention the 1688 Bill of Rights then? I guess if they've made the 1688 Bill of Rights and that is pretty explicit, what is it based on then? Well, I think that if they're not mentioning the 1688 Bill of Rights, but you're after 1688, then I think they must be referring to that charter that confirms the jurats and being sworn in legal basis for what the Bill of Rights is meaning and referring to. If they don't mention Magna Carta, maybe that charter, Magna Carta. Maybe I'm wrong, actually. Maybe in that William Penn and William Mead case, 1670, he says the Great Charter. Maybe he's referring to Charles's charter then. Unless he did refer to Magna Carta, the Great Charter. But really, it's the same thing, isn't it? You know, the peers, judgment of the peers and the jurats who are sworn in. Same thing. In 1772, this was placed in a chest in the vestry and not mentioned again until 1745, when the practice of handing it to the new mayor was resumed. From 1641 to 1702, there is a note that the common seal was handed over to two, or on one occasion, one of the jurats. Really? From 1641 to 1645, each year a number of memorandums how the corporation's money and certain charity money was invested, including reference to there was an increasing number of memorandums, the custody of corporation possessions. Brass weights from 40 fathoms of fox yarn. 100, 1/4 thing, weight of bullet and match boys. The deeds of certain charities under the parish is placed in the parish chest. Bronze gallon measurement of 9 pairs and a burning iron. A burning iron! Memoranda concerning custody began again and included weights and measures, fetters and burning irons on occasions. Other matters of the kind, usually dealt with at the assembly or common hall, were also considered. From 1640 to town. Scott was levied orders concerning the chairman's accounts of means. Summaries were given. Summaries were found at the end of the book. In 1751, it is noted that the balance of the Chamberlain's accounts had been passed at the previous quarter sessions in the Treasurer's Book of Account. Other orders made at these meetings include orders for the remission of fines, at a common hall, for the repair of the court hall, and handing over the town's documents. Investing Senate courts in port to Chamberlain's conduct. Election of the mayor took place at the meeting of the Common Hall. From 1660, the minutes of the meetings of these gatherings are recorded for these books. Specific times meeting all the minute book. So the minute book. So you think he's got the mayor a lot in this. That's like the Assizes, like in London. Somewhat haphazard meetings being recorded in front and the back set out, which way I resolved dealing with similar burdens as they can. The back part of the meeting, set up for the meeting. The court hall was burnt down, and as a result, meetings were held in April. It burned down. The new court and new gaol to be erected. Town Scott was levied to pay for the rebuilding. So Freeman should contribute to the expense of marriages and ceremony bodies and rooms. Oh, what's this? Conditions concerning an escaped prisoner, 1662, to the corporation suit against Robert Austin of Tenterden in the Queen's Bench for non-payment. The Queen's Bench for non-payment. Keeping watch on Denge Marsh. And the 700s were to be tried at the next Assizes. In July 1692, it is recorded that the Corporation of Tenterden and the 700s were to be tried. The hundreds were to be tried at the next Assizes. Mason for not keeping watch on Denge Marsh. They submit a separate defence and not to join with the 700s. I thought maybe they were using some of these buildings that corporations had a building that they used to meet for the assizes. That's what I thought it meant. To meet the Lord Warden of the St. Barnabas information received. Dissimilar should some consent the town records in. Regulations for the proceedings of the Court of Record were made in April 1704. And copies of Acts of Parliament were to be provided. Right. Including a provision of a book into which the proceedings were to be entered instead of being kept on loose papers. A new plain book and copies of Acts of Parliament were to be provided. Arrangements were made for the presentation of an address to the Queen, engrossing the seal of a common seal of the corporation. The question of the right of the freemen to use Smithfield Ferry free of toll was discussed. The corporation also asserted its right to accept the property of. Transaction was the subject of a protest by certain of the Jurats and freemen who stated the meeting that had made the arrangements to sell the property had been held in a regular way. The process is entered into the minute book. Other orders of a general nature include orders concerning fines to be imposed on new traders, setting up shopkeeping stalls and repairs and gear repairs, extension and remission in particular agreements for buildings. Whereby who is the director of part of the building of the corporation, orders of a particular nature. Appointment of the first sergeant of the mace as Bedell of Bridlewell. Appointed at the mayor choosing ceremony, the payment of and the decision to petition. All right, look, here we go. This is something now. Authorization of the mayor to fine at his discretion all plays, shows of any kind whatsoever which shall be exhibited in the town. And the authorization of the mayor to fine at his discretion all plays, shows, and I don't think Shakespeare would have been too happy with that. Right. July 1750. July 1750. And the decision to petition Parliament for a bill for repairing the Maidstone to Cranbrook Road, January 1760. That's why I clicked on this and opened it, just for that. So there was a decision to petition the Parliament. So this is, I think this is actually the local courts are deciding to petition Parliament. Like, I actually think that. So the decision to petition Parliament for a bill for repairing the Maidstone to Cranbrook Road, 1760. So they'll have probably needed to get a lot of people to get that put through. So they've got some consent there. Look, July 1750. So July 1750. In the minute book, it was recorded that they'd approved to petition Parliament for a bill for repairing the Maidstone to Cranbrook Road, but I wonder if we can find that petition. I wonder if that petition can be found in the transcribed petitions, and how many people signed it then. Maidstone to Cranbrook Road. Quarter sessions. This has got quarter sessions in title of court from 1641 to 1655, during the entries. Heading the sessions of the peace and guild delivery. Blah, blah, blah. The title becomes General Quarter Sessions of the Peace Gale delivery and view of plinkage and continue. Gale delivery. November 27, when the words Gale delivery are omitted. 52, the title is quarter sessions only. There are no entries. Gale delivery. There are no entries from October 1743 to 1751. From October 1758, view of Frank Pledge is there are the minutes give the little detail the court was called seems to have had little significance and does not appear to have affected what was dealt with by the court until 1758 when no partials were elected to the Michigan session with the view of Frank Pledge rules. The whole to this has become very previously held in to page. It looks like so this minute book, these minute books, it's got quarter sessions and assizes in. So they must have been when the judges came around. Obviously, so like they came around for a session 4 times a year, but also the assize judges came around twice a year. But they were really. It's kind of like this is the same. It looks like they're holding them in a certain area or town or village or whatever at the same place when it comes around, right? And it's like the records. Obviously, you need more. I think they're getting more serious justices to hear serious matters at those times, and then you've just got like your people who are your justices of the peace and jurats. Otherwise, this is to do with like when people are having to go to the Star Chamber and all kinds of things like that for certain matters. Although, if you're not in London, 6 months ahead. A fortnight or a month. In some cases, sessions were adjourned from 3 to 6 months ahead. Sessions were adjourned. So that's a long time to wait, isn't it? Meeting place after the court falls burned down until the court first sat at Woolpack, then at the George, and finally at the White Lion Inn. Minutes to the court chamber at the sign of the Queen's Arms during the mid-18th. The court sat first at the Woolpack. You're sitting in the pub. Meeting place at the court. The hall burnt down in 1661. That's when they had the tumultuous petitioning act in 1661. Maybe the villagers weren't right happy about it and they kind of rebelled and burned it down. Minutes to catch him in the court. The Georgian family recognised this from the memoranda. Sometimes at quarter sessions, but more often before small groups of recognises taken sometimes at quarter sessions, but more often before small groups of justices in between sessions. You can still get justice to consent. I've seen a petition. Do you know what? It's really funny because today, earlier on, I was saying, right, I think that they could just approach justices and get them to sign it, right? But I've noticed on some petitions, like the sheriff signed it on the petition, like there's one for like someone's not been repairing the road properly. It's actually got the signatures of like sheriff on it as well, which is some of them are serving or acting as justices. So it's like I think you could go like get like three people to sign it who have got the authority to sign it in order for you to petition Parliament. I don't think it has to be in the assizes or quarter sessions, but you can get the grand jury to sign it when they're assembled. But that's a session, isn't it? There are memoranda of recognisance taken sometimes at quarter sessions, but more often before small groups of justices in between sessions. Till April 1654, the recognitions are written out in full, but after that date, only a precedence is given until 1648, and then usually a note at the end of the recognitions to the outcome of the case. From 1651, the recognitions are written in English, but I'd like to see these, because they might have some consents to petition Parliament on there, but it's only telling you, it's only saying that they're just giving a brief outcome and so forth. Orders are on occasion recorded concerning such matter as the basis for assessment of when they. You want to actually really, you want to actually have a proper look at them and really go through them. I'm still just about appointments for street drive. Appointments of street drivers whose duty it was to impound straying animals were made sometimes at the Assembly, but in other sessions. For a time, the governor of the House of Correction was appointed at sessions. The borsholders for the 6 boroughs in the 100 elected for the following years were given each Michaelmas session. From Secretary, the names of the borsholders for the 6 boroughs in the 100 elected for the following years were given. Gradually, the court came to deal more and more with financial matters. In April 1672, it was granted a highway rate to the parish surveyors for Tenterden and a part of Epney in Tenterden in May 1729. I wonder if they got that Tenterden name from when they've been going over to America and interacting with the Indians. So around that time when William Penn's going over there, they've got this Tenterden term. 100 sesh was granted in 74 highway surveys were granted a land tax for their expenses from a large part of their recorded business relates to their granting of bridge, highway, gale and general rates. October 1674. The presentment of 9 people for lying at their own hands and out of service. Presentment of 9 people for lying at their own hands and out of service. 1674. That's before 1688. So that's I think that's falsifying some sort of claim. So it seems like they were petitioning for something, maybe lying at their own hands. So they were right. They were setting something in writing, and it was probably made out to be untrue. That's 1674. That's 4 years after William Penn was in Old Bailey. The presentment for 9 people for lying at their own hands and out of service. So that's what they're saying in the election petition rules, like 1960 and the Corrupt and Legal Practices Prevention Act, you're only entitled to a certificate of indemnity if you tell the truth. Like when you're sworn in onto the document that it's the truth. Like in the jury, you've got to swear to tell the truth. MPs are sworn in. MPs have got privilege, but only while they're telling the truth and as by law. It doesn't say they can completely and totally break and disregard the law. It says that they've got certain immunities and protections, but if they don't follow the law and if they're corrupt, it has to be investigated and tried and put right. And then they can possibly remove because they broke their oath, That's how it works. The indictment of women as a cheat, May 1759. I might take a screenshot of that one, actually, because that's useful evidence, including assaults on customs officers in the execution of their office. Public nuisances was used to fraud. In 2 of the men were hanged for both. 2 of them, people were getting hanged as well. They were still hanging people as well. The execution was attended by the mayor and 7 of the jurats on horseback. 1785. In August 1785, 2 men were hanged for burglary. The execution was attended by the mayor and 7 of the jurats on horseback and about 5,000 spectators. Can you believe that? 5,000? Really? 5,000 spectators? And in May, that's a lynching if I ever saw one. By the Chamberlain to the curate of Wareham for attending the condemned men was authorised by Quarter Sessions in case of in 1796 there was a case of highway robbery, but though sentenced to death, the man was pardoned, and a copy of the royal pardon made in the minute book. Oh, he got a royal pardon. He was sentenced to death. He must have petitioned for it. There was a case of highway robbery, but those sentenced to death, the man was pardoned, and a copy of the royal pardon made in the minute book. He must have petitioned. I bet he petitioned. That's petitioning the king. That right there. Look at that. In 1796, there was a case of highway robbery, but though sentenced to death, the man was pardoned, and a copy of the royal pardon made in the minute book. Between 1813 and 1818, there were several sentences of transportation for stealing, though one offender was pardoned. There was also a case concerning the seizure of wool in Tenterden by a customs official from Rye, which the court ordered should be returned to the owner. In October 1825, at the sessions of the peace, an order was made that arrangements should be made with the county justices for prisoners from Tenterden to be lodged in the county gaol and house of correction until 1830. The county justices for prisoners to be Tenterden. Special sessions for appointing surveyors of highways were held each year in October. I hope they weren't special surveyors who were allied and not impartial and completely biased to the interests of councillors and their private corporate investments, as investigated, on Colchester Council Watch with, the Balfour Beat Me and Care, taking financial gains out of all developments approved by the council. Court of Record from 1641 to 1701, there are recorded in, do you see those proceedings of the court of the Lord King, or Court Record, it was called, from 1721, concern on occasion, the cases were not frequent, and several pieces of education like their memoranda that proceedings or orders of some importance have been dealt with at this court. In the court of pleas as under the decrees relating to transfer, the minutes are entered in a meeting of Court Record at which it was decided that freemen were not to be forced to be jurats without their consent, and that townscot was to be levied. They were forcing people to be sworn in. It was decided that freemen were not to be forced to be jurats. Was this in local then? I did that in 1750. Particularly from 1760 onwards, there were occasionally memoranda of officers taking their oaths in the Court of Record. Of officers taking their oaths in the Court of Record, in there are recorded the proceedings of the commissioners set up under the Corporation Act in 1782 to take declarations against the Solemn League and Covenant on 24 August. The session was taking declarations. Also in TSE 2 is a list of jurats and commoners from 1704 to 1721 with later editions, and on the inside of the cover a note of. It says that they were sworn in, these jurats, and occasionally they'd be replaced. So they weren't. It doesn't seem like they were doing it. They're not doing it like they do now, right? You know, when you go to court and then you get jury service and then that's it, you go home and you're like discharged. They had like people who they were getting people to be jurors, which if you're being regular, what happens if people aren't too keen on you in the local area? You don't want them on the jury, do you? Although they're supposed to try to keep out of trouble, but they had jurors, and then some of them were falling low in numbers, but they didn't replace them until they got too low. But how many do you need? I thought you had to have a specific number. Or maybe it means like to choose from. They got certain people who sworn in, and then maybe like 20 people in the village, but you only had like so many at a time, and it could be from that pool of people or whatever. It seems to me like they were effectively. It says that all jurats are justices of the peace. If they passed that agreement that all jurats were justices of the peace, then it said that according to that James Charter. Oh, sorry, was that James I Charter? I forgot. It says according to that charter that they decided that the jurats were justices of the peace. If they were, then that means that they could get them to sign you could get 3 of them to sign the petition. It says 3 justices. It says you can get 3 justices to sign it, right? So if you could get 3 justices to sign it from the divisional hundreds county to petition Parliament with over 20 people, that means that you would only have to go get them. You would have to go find them and get them to sign it. And it didn't. If one of if any of them wouldn't sign it, you could kind of like get the court together and get the grand jury to decide it together. But the larger part of a grand jury. Well, the larger part of a grand jury. What about if it's a larger part of a grand jury, that maybe it means that you can't approach the jurats by themselves, but only when they're assembled. But you could, if it was that the assizes or quarter sessions, then you could get the justice, like the King's Justice, to. But he said 3 justices though. Said 3 justices, or a larger part of a grand jury. Well, they're jurats, aren't they? Then if it's a larger part of a grand jury. I've actually seen some of these petitions now with some signatures of like you might not know who the signatures are, because how do you know if they're jurats or not? They might have the jurats might have signed some of those petitions, but everyone who signs it is kind of sworn in on it though for the as a witness, aren't they? So you've got this approval for it until you want to extend it to get more people behind it. That it's odd though, that, because then isn't it really like you it's almost like you've got to get a large number of people who are sworn in order for you to get more people sworn in on your document. Constitution and names of those signing the resolution are given, including some of the. I think we get into all copies of the oaths of the mayor, deputy, Also, TES3 are copies of the oaths of the mayor, deputy mayor, jurats, justices, freemen, town clerk, and other officers, and a list of mayors from 1800, and a copy of the lease of the new town hall. Won't mind seeing those. I think we're nearly at the bottom now.